Hello, friends. Now we are going to talk about the next part, and that is parties to adoption. So, here we are going to first see who can take in adoption, and who can give in adoption, and who can be given in adoption. So, the first part deals with who can take in adoption, and here Hindu law has made it very clear that only one person can take a child in adoption. Because of this, clarification has been created in the capacity of a Hindu male taking in adoption and a capacity of a Hindu female taking in adoption. It is in no way different than each other. However, what happens is when people are married, there are two persons, and in that case, who can become the first person who is adopting the child? To answer to this problem, this provision has been created in this way. So, a Hindu male who is of sound mind, who is not a minor and does not have a son or a daughter of his own, can take a child in adoption. If he is married, then he has to take the consent of his wife. If his wife is there but is not capable of giving consent, then it is only in that situation that the consent is not required. In all other circumstances, the consent of wife is imperative. This means that unless and until the wife consents, a husband cannot take in adoption, which means when the husband is married, or when the people are married, both the parties' consent is required. Contrary to this, when a Hindu female takes in adoption, she is if she is single, it is only then that she can take in adoption, and if she has a husband living, then she shall not adopt unless the consent of her husband is imperative. If he is not capable of adopting himself, and if at all he is not of sound mind, or has been declared has renounced the world, it is only in these situations that the husband's consent is not required. So for a male as well as for a female, the consent of the spouse is a must. We go to the next part, and that is persons capable of giving in adoption. It is quite obvious that you have to be the natural guardian of the child. No other person can give a child in adoption unless the person is authorized by the court. All right. So if at all there is a child who is having parents, then it is only the parents who can give in adoption. And if there is a child which is of any other situation, which is an abandoned child or a child whose parents are no more, it is only in that situation that someone else can give in adoption. The adoptive father or mother can never give their adopted child further in any adoption. This is to stop any human trafficking which can happen under the guise of adoption. So, no person except the father or mother or the guardian of the child shall have the capacity to give a child in adoption. The father or mother, if alive, shall have equal right to give the son or daughter in adoption, provided that such right shall not be exercised by either of them without the consent of the other, or, as we have seen the provisions earlier, the consent of a person who is himself incapable of giving consent is not required to be taken. Where both the father and mother are dead, or they have completely and finally renounced the world, or they have abandoned the child, or have been both declared as unsound by a court of in competent jurisdiction, or where the child's parentage is not known, the guardian of the child may give the child in adoption with the previous permission of the court. Please understand, the permission of the court is not required when the natural parent is giving the child in adoption. It is required only when the guardian is giving the child in adoption. The Before granting this permission, the court has to be satisfied into all aspects regarding the ability of the persons who are going to take in adoption, the reason why this adoption should be validated, and it can also further give any permissions regarding the well-being of the child to be recorded under the Guardian and Wards Act. Then this is very important. The expression father do not include adoptive father and adoptive mother, and guardian is a person who has been granted the authority to take care of the child. The guardian can be appointed by will, that is called as a testamentary guardian. The guardian can be appointed by court itself, so that is a guardian appointed by court. And the court here means a court of civil jurisdiction, a city civil court, or a district court. We then go to who can be given in adoption, the person who can be given in adoption. So no person is capable of being taken in adoption unless the following conditions are fulfilled. Firstly, that the child is a Hindu. Secondly, that he or she has not been earlier adopted. Thirdly, that he or she has not been married unless there is a custom or usage applicable to parties which permits persons who are married being taken in adoption. This provision is applicable only in the Bombay school, or now which is called as the Maharashtra school. And lastly, he or she has not completed the age of 15 years unless there is a custom that such a child above 15 years of age can be adopted. This provision is also there only under the Maharashtra school. Thank you very much.